rise. Appeal in the matter of POW Campaign Limited and Waverley Borough Council.
My lords, I appear on behalf of the first appellant, my learned friends Mr. Stinchcombe and Mr. Wald for the second appellant.
Yes.
And then for the respondent, the local planning authority, Mr. Beglan and Mr. Ranatunga.
Yes. I might as well put this to you at the outset. I mean, we're hopeful that you and Mr. Stinchcombe have discussed how you propose to present the appeal, so we don't have any unnecessary duplication. We really do not want to hear the argument twice.
There are, we have, albeit briefly, there are some points of distinction in the way that we put our cases, and I will go first. I hope that will limit the need for duplication.
Yes, we have obviously concluded the appeal during the course of the day. Yes. All right.
My lord, your lordship should have a slimmed down bundle, which is SB, relatively thin. It's, I think we've removed some of the unnecessary surplus items for.
You're talking about the supplementary bundle, are you?
Yes, that's the bundle with the factual material, and then there's the bundle with the judgment and pleadings.
Yeah.
Primarily, I intend to refer to the bundle with the factual material, that's SB. Your lordship should also have a copy of an authorities bundle, and I think without further ado, there's some additions. I'm taking responsibility for all of these on behalf of the parties. So there's some additions to hand up, both for the authorities and some other documents that hopefully will help the court on each of those piles.
All right, well, tell us where they go.
Yes, so at the top, if your lordships remove the paper clips and things, the first documents are statutory materials. Some of these were referred to by the judge, and I think it's sensible that they're before the court.
You're looking at section, mine starts with section 19.
So section 19, section 28A through to C, and then regulation 10A.
Yes.
The section 19 and sections 28A through to C in the authorities bundle, they, I think, belong at the back of tab 1, because that's the 2004 Act.
Do they replace any of the materials in here?
They're additional. If your lordship noticed the red marking on them, that's simply so they're up to date as of the time of the decision. Those provisions have been since changed again.
So these are as they were at the time of the relevant decision?
Yes.
As is all the statutory material in tab 1?
Yes.
We don't have to do a journey here. We've got the provisions as they were at the relevant time.
That's my understanding.
They all go in as a piece today.
I think that's simplest, just to pop them all at the back of tab 1.
Yeah.
Separate then is regulation 10A.
Yeah.
That can go in at the beginning of tab 2. Am I right there? I'm sorry. My apologies, my lord. That's tab 3. That can go in at the beginning of tab 3. Then there's two additional authorities, both of this court. Odeby and Wigston, and Woodfield and Gallagher. And those it may be easiest just to put them behind tab 19. So they follow on from Gelson.
You know, you could have asked clerks to do all this before we came in, rather than wasting time like this.
Yes.
Yes.
Next is a single page of the NPPF that's referred to, I think, by all parties. The NPPF in the authorities bundle is tab 4. And if that page is clicked in after page 14, behind tab 4, after page 14, before page 38.
I'm sorry, this is in the supplemental bundle, is
In
it?
the authorities bundle. The NPPF is in the authorities bundle, so it's tab 4 of
Right.
that same bundle.
Yeah.
And then your lordships have the planning practice guidance on local plans. This is the last one, and I think it's appropriate this go just right at the end of the same authorities bundle. That's in the last document after the other EPG.
So what is this document?
That is quoted in my skeleton argument and was before the judge.
Yeah, but
It's
what is
the
it?
planning practice guidance on the preparation and examination of local
Right,
plans.
so everything behind tab 20 is planning practice guidance.
That's the outcome I'm seeking. It's
And again, as extant at the relevant time,
yes.
because it's online and it changes from time to time without notice.
Insofar it's not. Insofar as I rely upon it, and certainly the passage quoted that is extant. It explains the. I think there might be one bit of it that's been moved, but it's not relevant.
Right.
Um,
But it doesn't include the interactive map, I take it.
No, so the maps, I think both, I don't propose these be put anywhere but left out on your lordships' desks, and really once your lordships have seen them, I think your lordships will have the point.
Yeah.
The maps, both myself and my learned friends with the respondent with different degrees of sophistication thought it would be sensible for the court to have something showing where these various authorities
Right,
are.
we'll leave them loose then. Okay.
So I'll come to this briefly shortly.
Yes.
As your lordships will have appreciated, this is a challenge to the decision of Waverley Borough Council to adopt local plan part 1, that's the strategic part, with a very high housing requirement. And as far as material to the challenge, 83 dwellings per annum, not from Waverley but from Woking Borough, to be delivered in Waverley Borough. Over the 19-year of the plan, that is some 1,577 houses, which will have to be accommodated in the countryside of Waverley.
When you say in the countryside, is that necessarily so and agreed to be so?
It's necessarily so that some of those houses will be in the countryside, and one can see that, my lord, from the way that the increase has been factored into the policy ALH1, which essentially took a lot of the villages and augmented the number of houses that those villages would have to accommodate to cater for Woking. So certainly a substantial amount of that, I don't think it could be disputed, will be in the countryside. Indeed, in terms of substance, that's clearly one of the reasons why CPRE are pursuing this challenge. The question at the heart of this appeal is, what is the scope and nature of the analysis required when imposing housing requirements from one local planning authority area into another through the development plan process.
Well, does that mean that the question at the heart of this appeal is a question of the interpretation of policy and guidance?
Yes.
It does mean that.
In part. It's the policy and guidance, and I'll come to the relevant parts of the NPPF and the planning practice guidance, inform what that exercise should comprise. And indeed there's been case law, particularly in the development control context of individual housing decisions, which is relevant to that question. So in part it's interpretation. In my submission, my Lord, it's more how one properly applies that guidance.
Well, then let's focus on the concept of properly. So far as this court is concerned, and indeed the court below, properly means within the bounds of public law principle. Does it?
Yeah, I mean, it does. So there's some points of where, in my submission, the inspector's approach is adopted by the defendant flatly contradicts the guidance. One struggles to understand how the decision is in accordance with the guidance. And there's some parts where it really goes to reasons as to how this is
Right, so it's
expressed.
rationality and reasons.
Yes, my Lord, and it's that exercise of looking at what was done here in terms of the approach that was taken is to consider the circumstances that were before the inspector as well.
So you have to show that the judge was wrong not to find, in certain respects, that the inspector's approach, you have to show that it was irrational or not adequately reasoned.
Yes, in the context, my Lord, of the approach that's established in the guidance, among other things, that should be taken to local plan examination. So I'll come to my particular submissions on this point, but in short, our submission, I think shared by my learned friend for the second appellant, is that the assessment that was made of unmet need from Woking Borough Council fell very short of what's required.
Yes, but that's the sort of submission you'd be making at an examination or an inquiry. You're now in the court, and therefore we're in the realm of public law principle.
But it goes, my Lord, to the very essence of what was done. The inspector here, as I set out at the beginning of the skeleton, didn't even attempt to calibrate or consider what the unmet need from Woking should be, but relied upon essentially two very simplistic components: a need component that was based on something that 2012 household projections from the 2015 SHMA, which were inconsistent with his own reasoning for Waverley. And then on the other hand, a supply assessment that was based, in my submission rather boldly, on the 292 dwellings per annum requirement that was fixed in Woking's core strategy from 2012, that didn't ask the question, didn't even consider what the actual supply implications would have been from that. One gets, I'll come to this, but one gets a reference to the AMRs and a possibility of greater supply, but no engagement with the reality of that. And in my submission on the authorities, when a local plan inspector, and indeed a defendant accepting a local plan inspector's reasoning, is setting a requirement of objectively assessed need, I underscore objectively, he needs to carry out that exercise with some rigour and to address the robustness of the data that he's relying on.
But you're always going to get an element of statistical mismatch, aren't you, in these situations, simply because the development of the relevant local plans are never going to be proceeding exactly in tandem with each other. So where you have that situation, and this is one of those cases, the planning inspector presumably has to make a judgment, taking into account all the relevant material, all the relevant data that he derives from those sources, in forming a judgment on the particular issue of unmet need, isn't he?
And my lord, in short, our submission is that he did not make that judgment.
Well, that's what I want to be clear about. I mean, you can't win, can you, just by saying, oh well, his judgment, don't like his judgment, or it wasn't quite right. I mean, you've got to. I mean, there's clear room for disagreement in those sort of areas, as we all know. You've got to show, haven't you, that it was legally flawed, either because it misinterpreted the relevant planning directives, such as they are, or as my lord has said, was in some other way sort of Wednesbury unreasonable.
In my submission, there was a clear legal flaw in the inspector's, and one can see this in the footnote, his self-direction that it's not his role to do any assessment of Woking's unmet need. And in my submission, it was his role to do that. Had he appreciated that that was something that he should have engaged with, there were some substantial factors that were raised in the consultation responses, among other things, that he should have had regard to. And there's a number of ways he might have done it. He perhaps could have applied his judgment by making some assessment on the material before him, and that, in my submission, would have led to a significant downward assessment of that unmet need. As I go on to say in the skeleton, I'll come to in my submissions, he could, given the way that this arose very late in the inquiry or examination process, he could have sought further information, or he could, and there's specific guidance on this, in order to make the plan sound, not have imposed this requirement at a 50% level.
He could have done several things, Mr. Westaway.
Yeah.
We need to look at what he actually did. It would help me, at least, if we could isolate this clear legal flaw, as you submit, in the self-direction as to his role. If we look at SB 11, which I think is the right part of his report.
Yes, ma'am.
Before you go any further, it would help me if you could kindly isolate the presence of this clear legal flaw in his analysis. Where is it to be found?
My lord, the relevant section is where he justifies the 83, is, your lordship's in the right place.
Paragraphs 26 and following. Where's the clear legal flaw?
If I can take it in two stages. The inspector comes, first of all, to an in principle conclusion that unmet need from Woking must be addressed in Waverley. One can see that at paragraph 27.
Yeah, so is there a flaw in 27?
the first paragraph 28. If I can come to that, and then, my Lord, the footnote 7, which refers to potential reviews of Woking's local plan and the opportunity to re-examine housing opportunities.
Well, he
Justice
says,
this
he
is in
starts
paragraph 28.
footnote 7 starts with recalculating Woking's OAN in the light of the 2014 household projections is outside the scope of this examination.
My Lord, and if one looks at the text that's associated with, the inspector is saying that there will be this opportunity to re-examine housing.
Right. Is that a clear legal flaw?
In my submission, yes.
That's a clear legal flaw.
Yes, and I say so for a number of reasons, but principally because considering and giving a proper scrutiny to what the objectively assessed need is, and there's questions as to what extent, whether maybe he didn't need to approach this with numerical exactitude, but to engage with the arguments about the robustness of this approach, the out-of-date schmar against the 2012 core strategy requirement. That's where he got the numbers from. He needed to engage with that. Instead,
You say he needed to engage with it. I'm struggling to translate this into the language of public law at the moment. Can we try and speak that language together? What is the nature of the clear legal flaw? Is it irrationality?
my Lord, I think in terms of public law, the primary point here is a failure to, and one can put it in a number of ways, as often one can.
Well, how do you put it?
A failure to have regard to the key material consideration that the inspector ought to have been focusing on when imposing this housing requirement, which was the actual level of unmet need in Woking.
Well, you've got to, I mean, it's clear from footnote 7, isn't it, that the inspector was well aware of the possibility that what he calls the SHMA figure, the 2012 figure, could be an overcalculation and would need adjustment in the light of the 2014 projections. I mean, and he says he's taken that point into account and accepts that this may result in some reduction in the degree of unmet need. But having done that, he decides to go ahead. I mean, your submission, I think, amounts to saying that he shouldn't have gone ahead at all, isn't it? That you should simply have. I mean, if he's got to do the calculation of unmet need you're submitting, he simply couldn't have proceeded any further, could he?
He's placed, I think, as the judge below accepted in a difficult position. And in my submission, he was faced with evidence that seriously questioned the basis of the unmet need figure on which he set the proportion, this 50% proportion. He doesn't address those points, and those points are the out-of-date figures. I appreciate he mentions it, but he doesn't address them in terms of the unmet need figure, the problem with the need requirement, the potential for additional supply from Woking.
So in every one of these cases where there's an asynchronous, almost necessary asynchronous development between local authorities, and where there is the development of need figures over time based upon all sorts of demographic and econometric considerations, an inspector facing this circumstance does not find a pragmatic way through, which it is arguable this inspector did, but stops, because to do anything at all in that circumstance is flawed. I'm a little troubled by that, and wonder if you've defined your legal flaw too narrowly, in order to allow you to expand where I think you want to go. Can we just come back to my Lord Justice Lindblom's legal flaw point? Again, you started in two respects as to the interpretation of policy and guidance. Well, one accepts that you have yet to take us to the thrust of that. You may say that the whole of this process misconceived something. But the second element, which I thought we were emphasising for the moment, was the proper application of guidance. What else, if it's not a pragmatic solution, was this inspector bound to do? How would he have gone forward if it wasn't by the route that he took?
In my submission, the three options for this inspector, I'll come to them, were firstly to address, rather than leave hanging, the issues with the unmet need figure on which he based 50%. And it's crucial in a way how late in the process this arose, but there were some substantial objections in the McDonald report of October 2017, which are not addressed. He didn't do that, so one doesn't know how he would have factored those points properly into the unmet need calculation. But it's important, especially in the policy context here, that the inspector could have sought further information. Or he could, instead of imposing these 83 dwellings per annum across the whole period, built in some requirement for a review. Those two options, which as far as we know there's no consideration of by the inspector, would have been alternative, pragmatic and policy compliant ways of addressing the objections. Instead, what the inspector did was not to determine the unmet need, but to rely upon these out-of-date figures, not to go back and think what the implications are of the criticisms for that figure, but to focus on the percentage, the proportion. And in my submission, as I set out the skeleton argument, that's approaching it the wrong way round. One cannot know what an appropriate proportion is until one knows what the figure that one's basing the proportion on is. So the inspector needed to do more than, as he does, if your lordship still have SB 11, as he does simply recite at para 26 these two figures. One gets then the 225 dwellings per annum unmet need, and to base everything else on that, and then to note various factors that, and I draw attention to it, my lord, in the skeleton, but one can see the way that the inspector refers to possibility of review, possibility that housing delivery is higher in Woking. In terms of it, this is para 29. In fact, while I'm here, I may as well give your lordships the four references I rely on for this point. Bottom of para 28, very probably, second line up, underline that. Para 29, sixth line down, the scale of undervision could be. Next sentence, it is also possible Woking might deliver. And then indeed in the footnote 7, last sentence, may result. The inspector has left the actual implications of these factors undetermined, and in my submission, given the importance of objectively assessed need, albeit this is another authority, albeit there might be some issues where one authority is preparing its local plan in a slightly different order, they needed to be engaged with by the inspector at the time that he was making his decision.
Mr. Westaway, he does engage with the question, which is implicit in the heading of this part of his report, doesn't he? Meeting unmet housing need in the housing market area. No doubt he could have done other things. No doubt in a perfect world he would have had more information. But he did resolve the question how to deal with unmet housing need in the housing market area. He resolved it in the way that he did. You have to show that what he did was either plainly contrary to the purport of policy or otherwise irrational. And at the moment, I think we're having difficulty isolating the irrationality in what he actually did. There are all sorts of things he could have done, no doubt, and several things that the CPRE and POW would have wished him to do, but he didn't.
My lord, it's a little bit more than that. There was I'm not sure it's in your bundle, but there was a representation from one of the developers to say that you need to look at objectively assess need from Woking in a lot more detail. What the inspector has simply not done here is to scrutinise what the objectively assessed need from Woking is as at the date of his decision. What he's done is to rely upon these two figures, which gave rise to some very significant question marks. To note then, almost in passing, that there's a number of things that might affect the robustness of these figures, but not to engage with the implications of any of those points for that objectively assessed need figure. And in my submission, one stands back and is a high policy point in a way to think, well, what is the purpose of local plan examination? Is to try and have a robust, sound basis for housing delivery in a local authority area for the whole entire plan period.
This is not a merits appeal from that exercise.
It's an appeal. I mean, it's an appeal of law.
Well, these proceedings are not a merits appeal from that exercise.
My lord, that's not lost on me, and I hope in my skeleton.
That's why we're urging you to help us by identifying something that is irrational in this analysis, or flatly contrary to written policy.
My lord, in terms of the policy, if I may, I'll come to that. But I'll come to that. I do say that this was contrary to policy in a number of respects, and the inspector didn't engage with those points. It may be, if I can just move on and finish this introduction, I'll touch on those points as I develop the argument. Two just background points. It may be useful for your lordships to look at the interactive map, and behind that you have, I think, part of Mr. Parrott's exhibits.
Well, I hope your interactive map is clearer than mine, because apart from the place names like Guildford and Woking in bold, the rest is a complete blur.
Yeah, it's all it shows really, my lord, is the...
But it's not, you don't require anything more detailed than that.
Well, your lordship will see the housing market area in this case was Woking, Guildford and Waverley.
Yeah. It's the entirety of those three boroughs and only that area.
Yes.
So if we highlight, while I'm doing it, the boundary, the outer boundary of those three authority areas, that's the housing market area.
And your lordship will see the same, just those areas in colour behind Mr. Parrott's exhibits. It's paginated. This was the High Court pagination 1045.
What's the whole of the coloured area? Is it?
The whole of the colour area is the combination of the three boroughs, and I think the line in green, red and blue shows the different local authority areas. Woking in the north, Guildford in the middle, Waverley in the south. In his representations, we'll come to Neil MacDonald, who made, by submission, what's the key objection when this point arose, refers to these authorities as a radial slice around London, which I think is a fair enough way of describing them. But they're the Housing Market Authority. In terms of the position in Woking, my lords, one factual point to note, and this was brought to the attention of the judge because it was between hearing and judgment, is that on the 18th of October 2018, Woking reviewed its unmet need using the later 2014 household projections and the updated method, and concluded it had no unmet need. The document that was put before the judge is at page SB 367 to 368. I don't think your lordships need to turn that up, because I don't think it's disputed. But Woking concluded no unmet need. The number was reduced. The need figure was 409 dwellings per annum, and the delivery in Woking was said to meet that.
So your client's grievance is, as it were, accentuated by events after the event, because Woking on its own showing now says we have no unmet housing need.
This was, I mean, my lord, this was after the claim. I mean,
Yes, but it's got no bearing, has it, on the lawfulness or otherwise of the exercise we're looking at?
We certainly don't say that the inspector would or had to come to this same conclusion. But it's material, my lord, that it demonstrates that had the inspector had regard to the up-to-date evidence, the 24 projections, factored those in somehow, had he considered the actual supply in Woking, and they're really the two key points that were raised before him that he didn't address, that the unmet need in Woking may have been much less or indeed none. And the point is, he didn't do that exercise. He noted these points, the possibility that they may change the unmet need figure, but he didn't do the exercise of seeking to consider what that objectively assessed need from Woking actually was. And one can understand his reluctance to do it, and I'll come to the facts in this case as how it arose. One can understand perhaps his reluctance to do it, but in my submission he needed to do that in order to conclude that this was a sound plan. Otherwise, he's relying on data that's, one, out of date, two, challenged, and three, not doing the exercise that policy requires him to do.
Was he mandated to do that by any statement of policy or guidance?
My submission, yes.
Where?
The key guidance on this, perhaps let's go to the policy context. One finds it in the MPPF and the PPG. I think I do include some of this in my skeleton argument, my lord, at paragraph 17, and my learned friend does in his as well. But if we go to the NPPF, that's tab 4 of the authorities bundle. The references, I think, that suffice for these purposes. The first point, my lord, is the need to consider objectively assessed need in the housing market area. Paragraph 47. Paragraph 47 is primarily, my lord, aimed at local plan, is my understanding of it. bullet point 1, local planning authorities should use evidence base to ensure local plan meets full objectively assessed needs for market and affordable housing in the housing market area as far as is consistent. So a clear policy that question needs to be engaged with, and it is the objectively assessed needs
In the housing market area.
in the housing market area. So the inspector was right to look at that question, but wrong in my submission in terms of the assessment that he made. He didn't do the up-to-date, objectively assessed needs. And the next reference on this point is 182. Sorry, before we get there, perhaps it's worth picking up all of the points in the order they arise. 158. and 159 are allowed in particular. 158 is that local plan should be based on adequate, up-to-date and relevant evidence about various factors that clearly includes housing. So
What do you rely on in 159?
in 159, it's clear understanding of housing needs in the area.
No, in their area.
In their area.
Yeah.
Well, the housing needs in their area will, in terms of the HMA, is going to include that, but it's the need for a clear understanding. And in my
And you say that the inspector didn't do that.
what the inspector did is, in terms of the need arising from Waverley, he's come to an assessment. It's not a hugely onerous task, but he's done it. He's had regard to various signals and factors. He's updated that for.
So, just to be clear, I'm sorry, this is an entirely neutral question, Mr. Westerway, so just help us, please. Do you submit to us that the inspector did not do that which the first sentence of paragraph 159 says LPAs must do?
In my submission, the inspector did not come to a clear understanding of the needs in the area as they arose from Woking. He refused to do that, and we've seen what he said about that at footnote 7. In terms of 158, I covered that, but that's the adequate, up-to-date and relevant evidence. There was more up-to-date and relevant evidence from Woking that the inspector should have had regard to. My Lords, the last reference I think from the MPPF for present purposes is 182 under examining local plans. And this goes more directly to the role of the inspector, and it maybe said, well, he's looking at soundness, that's the review that he's undertaking. But in looking at soundness, the inspector must make sure, and it's the first bullet point, that the plan is positively prepared, based on strategy which seeks to meet the objectively assessed development and infrastructure requirements, including unmet requirements from neighbouring authorities. So it's the need to undertake the objective assessment and the failure in my submission of the inspector to do or appreciate that, and then of the defendant to rectify that, or they simply adopted the inspector's reasoning on the point. That's at the heart of why I say it's unlawful.
So let's characterise it. Failure to understand and apply relevant government policy. Yes?
Yes. In terms of considering what the objectively assessed need actually is, on which the inspector is imposing housing requirements. My lord, all of that in my submission is supported by the guidance. Tab 20 of the bundle, your lordships have the planning practice guidance. This is on housing development needs, and as my Lord Justice Lindblom observed, I think this may have been updated since, but this is the version that was in force at the time the inspector made the decision and the defendant adopted Local Plan Part 1. Methodology, my Lord, in terms of pages 5 of 17 is para 14. Methodology is addressed there.
So there's a page at the bottom, a paragraph at the bottom.
Far bottom right-hand corner, there's some small pagination numbers. So it's 17 pages in total.
No, I've got the pagination. It's the paragraph at the bottom under methodology assessing housing needs.
Yes, that's and that provides some guidance which the court, I think, has seen in other contexts. Establishing future need for housing is not an exact science. No single approach will provide a definitive answer. So no approaches can be taken, but future need for housing must nonetheless be established, and it may not be an exact science, but it's still an objective exercise. Over the page, so page 6 of 17, clear indication that the starting point for considering this question should be the household projections, and this links back, my lord, to MPPF para 158 and the need to use up-to-date evidence. The household projection should be the starting point. And my lord, there's a discussion there I may not need to go through, but your lordships want to cast their eyes down. But in the next paragraph, para 16, under the heading, how often are projections updated? Clear guidance, 1, second paragraph down, that local needs assessment should be informed by latest available information. So that links back to MPPF 158. And it follows that one would expect this exercise to be done, i.e. against up-to-date information, unless it cannot be done. And in my submission, the inspector in this case could have done that, and it would almost certainly have reduced the unmet need from working. Certainly one doesn't get in the inspector's report a discussion of, well, on balance, I think that the numbers wouldn't have changed very much. One, as I've already submitted, the the numerical implications are simply left hanging.
The information you're referring to is the 2014 household projections. Yes?
Yes.
And anything else?
My lord, the next paragraph says...
Sorry, Mr. Westerway. My question was not precise. Is there any other latest available information other than the 2014 household projections which the inspector did not take into account and should?
In terms of the arguments made before the inspector, there was that, and the other key point, because I think clearly one can see some points being less significant than others, but the other key point was the supply in Woking. So on the need and supply side, and I'll come back to both those parts. But clearly, unmet need is a calculation of need minus supply.
So those two principal elements of latest available information. Yes?
Yes, they are. They're the two principal elements. My lord, I don't want to labour the PPG. The next paragraph, can adjustments be made, also relevant, I think, to the general submission that when looking at that there should be, well, first of all, that household projections are considered to be statistically robust, and if one's not going to follow them, this is the second paragraph on page 7 of 17, changes should be clearly explained and justified. If I can, behind that same planning practice guidance, I think your lordship's inserted the local plans PPG. If I can just refer your lordships to the part of that I rely upon, see where it sits. On the first page it provides some general guidance about local plans that the court will be well familiar with. It's on the second page, page 2 of 8, that I draw attention to in the skeleton, and again before you. It's what is the role of the examination? And in my submission, this is relevant to the question that my Lord Justice Ryder asked about what does one expect an inspector, indeed a local planning authority, to do. Under the bullet point, so it says the third paragraph down, it says the inspector should work proactively with the local planning authority. Underpinning this is the expectation that the issues not critical to soundness don't cause unnecessary delay. Well, in my submission, the objectively assessed need is critical to soundness. Inspector should identify any fundamental concerns at the earliest possible stage in the examination. In this case, largely because the local planning authorities, all three of them, agreed not to raise this issue. The issue was only raised by the inspector himself very shortly before the hearings. In his
Well, that was proactive, wasn't it?
In terms of what the inspector did, I don't criticise him for raising it, but it's relevant to note when it was raised, and it was not the earliest possible stage.
Are you criticising for that?
I think it's fair to criticise the Housing Market Authority council.
Are you suggesting that parties did not have enough time to deal with the point?
But it's in terms of the consideration the inspector gave, the substantive response that was sent by the first appellant, CPRE, on this point as to what is the objectively assessed need, was in October 2017. So it arose very late, and in terms of why it might be that error was made in this case, it may well, in my estimation, have quite a bit to do with the fact that it was raised late and later than it should have been. But that doesn't justify the error, especially where, and I'll come to, because the bullet points flow one into the other, especially where there are ways that inspectors can manage circumstances such as this. That third bullet point deals with one of those, where these issues cannot be resolved within the timetable, potential of suspending these.
It's just to deal with that third bullet point, and forgive me for not knowing this, did anybody actually ask for a suspension?
No, not that I'm aware of. Well, as I've said, and it's a key document that I'll take the Lordship's debriefing in due course, but the MacDonald report made some criticisms which I think it hoped that the inspector would have regard to. I think the MacDonald report is pretty clear in saying, well, if this is a real issue, we assume the inspector's not going to proceed with this. I'll come to it. But that was as high as we put the case. We didn't say, you must get more information. We said, just stop and check. I think that does deal with the third one. And the fourth one is consideration be given to the option of the local planning authority making a commitment to review the plan or particular policies of the plan within an agreed period, where this would enable the inspector to conclude that the plan is sound and meets other legal requirements. So one has there, and it's relevant here, because there was a statement of common ground between the housing market authorities that they would do such a review. And it's relevant here that that is in the planning practice guidance, an option that's flagged before an inspector, placed in the position this inspector was placed in. You didn't need, even if he wanted to get on and speedily approve the plan for other reasons, he didn't need to build in the 83 dwellings per annum. I think what I propose to do is to start with the case law and take that quite briefly. Your Lordships will know this court's own case law and what I say about that and how it applies. Then touch on the key factual points, and then, which I can do largely by reference to my skeleton, come back to the grounds that we make, if that's agreeable.
Case law is quite familiar.
And I think for that reason, I hope to be able to take it fairly.
The essential principles in the case law, as far as it bears on assessing housing need, are apparent in Jelson and Hallam Land. Yes?
Yes, my lord, I was going to start by briefly referring to those two cases. Shropshire, which was a decision of Mr Justice Lang in the High Court that's referred to in the Hallam Land case by Lord Justice Davis, is also a relevant case. But I hope not to take too much of the court's time on these points. The key distinction, of course, between this case and
This is a local plan case. Those others were appeal cases.
Yeah. But in the context of individual development consent decisions, it's been held that very often it will be necessary for an individual inspector, considering individual cases, I suppose the same applies to a local planning authority, to determine objectively assessed need. Not local plan context, but inspectors have to determine it to some degree, and that's clear from the case law. It's related to MPPF Para 49.
47 and 49.
And 47 and 49 taken together. And my lord, it follows from that inspectors in that development control context must engage with the issue of objectively assessed need, must determine the extent of the shortfall, the need and supply. Hallam Land, I think, is the most useful authority to ask in answering the question in that context how numerically precise do inspectors need to be. Your Lordships have Hallam Land tab 18 of the authorities bundle. Within that, the key reasoning of my Lord Justice Lindblom starts at paragraph 47. That's why it needs to be done. Then over the page, three propositions, and the degree of precision is addressed at paragraph 52. And in short, what this court held was that at least in that development context, in development control context, the inspector would normally have to identify the broad magnitude of the shortfall in the supply of housing land. So,
Do you say those principles transfer to the present context or not?
in my submission, they transfer with added force. The implications in a development control decision context are for a single development site. The implications in a local plan context are for a development plan period and an entire borough.
And you include all three of the principles that I set out, do you? We'll put three main points, I call them.
Yes, in terms of the second point, that my Lord doesn't refer to some of the paragraphs of the MPPF that don't relate specifically to decision taking and relate more to local plan, but certainly in terms of there is planning judgment here. Paragraph 50, that applies. Under paragraph 52, where your Lordship said the MPPF does not stipulate degree of precision, it does in the local plan context, as I've referred to, stipulate the need for adequate and up-to-date information, and we went to those paragraphs. So as I said, in my submission there is more force in the policy and guidance context here as well. The other reference won't be lost on your Lordships to this, as Lord Justice Davis agreed, and para 83 and 84, that's where he refers to the Shropshire case. Your Lordships have the Shropshire case at tab 15, I may not need to go to it separately. So para 83, Lord Justice Davis quotes Mrs. Justice Lang: inspectors generally will be required to make judgments about housing need and supply. However, these will not involve the kind of detailed analysis which would be appropriate at a development plan inquiry. And note that Mrs. Justice Lang went on. One look, perhaps it is worthwhile just looking at the Shropshire case to see what she went on to say after those words. This is para 27, tab 15. paragraph 27. She's referring to some passages in the judgment of Mr. Justice Lindblom. The quoted sentence is the middle one in paragraph 27. It goes on to say, the inspector of the planning appeal is only making judgments based on material before him in a particular case, which may be imperfect. He is not making an authoritative assessment which binds the local planning authority in other cases. So it's really for those reasons why I answer my Lord Justice Lindblom's question with more force, because the implications are more significant. Last point, specifically on the development consent process, is to note that in considering objectively assessed need, inspectors, indeed the same would apply to local planning authorities, are not bound to follow the evidence in core strategies or in SHMA's strategic housing market assessments. They must consider the up-to-date position, and indeed the case law full of examples where inspectors look at and scrutinise the evidence base in an SHMA or in a core strategy and say, well, that doesn't really help me with the objectively assessed need now because things have moved on. The Odeby and Wigston case, I think, which is one of the additional ones I handed up, and my Lord Justice Lindblom will remember, is an example where some significant criticisms were made of the SHMA. So it's clear that in that development control context for individual appeals, decision makers are often called upon to assess objectively assessed need, and in that context have to consider the broad magnitude of that need against up-to-date figures on a robust basis.
Broad magnitude.
And in my submission...
Sorry, you submitted broad magnitude?
Yes. Yes, I'm simply following Hallam Land,
Yeah.
but this is for development consent decisions.
Yes, but you said that the principles applied with added force is what you submitted.
Yes, and whether I explain myself fully, they apply the principle in terms of the need for in terms of the need for exactitude. That is greater, if anything, at the local planning.
The submission is that there's a need for greater exactitude in the local plan context.
For the reasons I've taken before. So I hope that's clear. And in terms of the distinctions between the development control process and local plan exercises, we paused on the Shropshire case. In the Odeby and Wigston case, my Lord Justice Lindblom made the comment at para 35 that it's important to keep in mind the essential difference between those activities. The same points made in the Gelson case at para 49. So there is no doubt that the principles, in terms of looking at one, it's going to be to some extent relevant when looking at another, but it's not the same exercise. And they're going to apply a little differently. When I say with added force, I mean with greater need for exactitude. There was some discussion in the High Court and again before you on Gelson. Maybe worthwhile just going to Gelson. This was a dispute. This is tab 19 of the authorities. This was disputed calculation of objective for the SSB by an inspector. Again, it's development control decision. This was a case where the core strategy wasn't relied upon. And the key paragraph that I think all parties cite before you is para 25, page 14, para 25.
Do you say that those principles apply with added force here, or with equal force?
In my submission,
I mean, if they're right, that is.
I don't object to this as an entirely appropriate and correct description of the exercise before a inspector considering development control decisions. What's said in the court below was that this, the planning judgment that's referred to in Gelson is even greater, or at least as great, or I think possibly even greater, is what the deputy judge said below, in a local plan exercise where one's looking at housing market authorities. And in my submission, that one should approach that with a degree of caution. Clearly, in a development control decision where one has limited parties, inspectors often have to do their best on the information before them. In a local plan exercise with multiple parties, including, of course, the neighbouring HMA authorities who would be party to that process, and working was in this case, one has a wider purview, and it's right that the information that's considered, certainly if it is raised before them, that the information considered by an inspector in a local plan exercise, therefore is wider in its nature.
I mean, you could say, I suppose, that a local plan process, in the way that it's set up, certainly these days, has more the flavour of an inquisitorial process than does the Section 78 appeal process, which is distinctly adversarial. Is that right or not?
Yes, in my submission, and certainly, I mean, in terms of the duty on an inspector to ensure that they have all the adequate information. One can imagine if there was a local plan exercise where an inspector was just not given some information about supply side at all, there's nothing, and just said, well, it's all needed, therefore, it would be a clear case that the inspector should have made some inquiries as to what the supply position was. In this case, the inspector simply relied upon the core strategy 292 figure, but didn't make any further inquiries in terms of how that figure might be affected by supply. Simply flagged it in passing. So, I support that approach, and I think in terms of the Thameside duty, that's also relevant. The other point that I note in the skeleton and draw attention to again is, in this development control context, clearly as the Court of Appeal held here, this is about halfway down, it may well be sensible to adopt a range. A range may be right, may be appropriate, but that does not make sense when one's looking at a local plan requirement where a figure is needed. So local plan requirements in the material considered is wider. The process is more inquisitorial. And the focus is required to be more specific.
Yes, somewhere in one of these cases I used the expression doing the best he or she can. I can't remember where it was, but I found it when I was preparing for this hearing. Reflecting on what you've submitted to us thus far, it might be close to enable simplification, but it's probably true that you're submitting that the inspector here you submit did not do the best he could on the material available to him. Is that what you submit to us? The inspector did not do the best he could have done on the material before him, as was required by policy, and thus failed to apply policy. Is that what you're submitting or not?
Yes, yes. It goes hand in hand, though, my lord, with then, as part of the material before him were the, not just the figures he had, the 292 and the 517, so the two components of the unmet need, but the serious criticisms that were made of them. What the inspector needed to do was to address those points. And consider the implications of them for his conclusion. I should note that in terms of the basic point here, that local plans require some more detailed consideration than development control decisions. There's a degree of common ground between the parties. I'm referring to my learned friend Skeleton argument, para 23.
Mr. Beglin's skeleton argument.
Mr.
And what are you agreeing with him?
There's a degree of common ground in relation to para 23, in that what Mr. Beglin accepts is that in the local plan exercise, determining whether the local plan is sound, in the sense of being positively prepared, etc., the approach would be at least as thorough. I'll go a little further than that, but then he adds in parentheses, if not more so, given the wide range of evidence on that issue before the examination. There's an undercut recognition of the broad scope of judgment, but in terms of the exercise that's needed, there's a degree of common ground. And just to reiterate a point that I hope is clear from the skeleton, in terms of the justification for housing numbers in a local planning authority area, it matters not whether that justification is from need identified in the area or out the area in principle. The housing is the same, the impacts are the same, and in principle, the justification for meeting that need should be just as strong. In principle. And we've seen the various exhortations in my submission are consistent with that in the MPPF. There may be practical considerations in terms of the evidence that one can get from a neighbouring housing market authority area, but that doesn't mean that an inspector is entitled not to engage with the in principle question, which is, what is the objectively assessed need on which this housing is required, and therefore which justifies the inclusion of this 1,500 or so houses in the local plan. The court will be very well aware of the description of local plans in the Tesco and Dundee case, a carefully drafted and considered statement of policy, para 18 in Tesco and Dundee. consequence of a local plan is that decisions must be made in accordance with it, with considerations in it. Otherwise,
We have a plan-led system with a statutory presumption in favour of the plan in a development control decision.
so and that underscores, so in a way, the purpose of the law here underscores the need for inspectors to get it right. My Lord, I'm conscious of the time, but I'm getting through the points. On the facts, I deal with, I think, the key factual points in my skeleton argument at paras 9 and following. So I'll try to take them fairly lightly and just flag up some of the key factual points.
The facts really aren't controversial, are they? The judge in the court below set out a narrative that I don't see as being controversial. Is that right?
There's nothing
Right. Well,
particular controversy.
for my
in
part,
there.
do we really need to go through the narrative again?
If I can just draw attention, if I can aim to do it this way, to use the skeleton argument as a sort of springboard, and simply to take your lordships to a few key documents. At para 10, skeleton argument, I make the point that as submitted, there was no provision for need in Waverley from Woking. And my lord, that reflected the common position of the parties. And there's two documents which I think are in the in the SB bundle on this. First, Woking's pre-submission response. This is from Woking itself, SB 194. Starts at SB 194.
Yes.
And one can see it's on SB 196, the approach that's being taken by Woking. Para 47 is referred to para 179. It says the council is aware of the information Waverley Borough Council has published which demonstrates unmet need from Woking cannot be met in Waverley. Once this evidence is agreed at the examination, just over halfway down, once this evidence is agreed at the examination, the council is willing to cooperate to find ways of how the overall unmet need can be addressed. Next document is the behind the statement on the duty to cooperate, tab 3, page 39. It's slightly further on, December 2016.
The document we've just looked at, date
October.
16.
And this document reflects that position. Indeed, it's a common position of all three of the authorities.
So now we're in December 16.
This is the submission. You're on page 40, SB 40, there's the contents. More of it was before the judge, but Appendix 7 is what you've been provided with on SB 41 and 43. And it's on SB 43 that one can see the approach that's being adopted, common approach by the authorities. The top of page 43, all three authorities seek to involve legal boundaries, current evidence base is referred to. first main paragraph, second paragraph, I apologise, second paragraph, all three local planning authorities acknowledge the need to work together. The court reads down there in the next paragraph with the bullet points. And my lord, the points to emphasise there are there's two really. First, that the representation was that the assessment of needs in the housing market area should be based on common methodologies and assumptions to ensure consistency. So the point about consistency is flagged up. Need to adopt a consistent approach, which makes sense if one thinks about need. If one knowingly adopts an approach that's inconsistent, then one has a very real risk that the conclusion is skewed. And indeed, as I say in Skirts and Argument, part of our complaint here is that the approach adopted by the inspector did anything but ensure consistent methodologies and assumptions. It built in inconsistent methodologies and assumptions. More generally, what the housing market authorities were doing was not to provide information to the inspector about the unmet need. They were not inviting the inspector to address unmet need. The invitation to the inspector was, this is a matter which we dealt with by review with us, and he can leave it for that. Now that, of course, doesn't prevent the inspector from entering into the arena, from considering unmet need. But it does, as a starting point, call for some caution, because he's not got information from these parties on it, and they were indeed positively promoting a different approach. So, my lord, in the skeleton now, para 12, I set out, and I think I don't need to go through all of this. I'll come back to the McDonald report. I said what the calculation was that was relied upon by the inspector, and I've just asked the court to note, in addition to the points I made in para 12, that the calculation, as far as we can see, and this is a point referred to by Mr. MacDonald, originally comes from a pre-submission representation from a developer. So the 517 against the 292 that gives the 225 that's then halved and shared out originally comes from a developer's representation, and you've got that behind Mr. Parrott's statement in this bundle SB 345.
So what's the significance of that?
That's where it came from, and it was not developed in my submission beyond that.
What's the significance of that point? The fact that it originated with a developer?
Well, my learned friend relies, among other things, on this was a matter of debate. It was raised. Developers said that it should be higher, and the percentage should be higher. But there was never anything.
Are you suggesting that less weight should attach to it because it came from a developer?
No, my lord. It's the origin of it, though, is there. As far as that, so it did not come from an assessment by the housing market authorities. That's the origin of it. That's the relevance. One has a situation here where the housing market authorities are actively not engaging. One has, and it's para 4.12 on page 345, what seems to be the origin of the point being taken, and it's never developed beyond that simplistic analysis of 517 against 292. Even, my Lord, has put by its NLP in that document, they refer to these two, the origins of these figures, and then say the implication is that the adopted housing requirement falls short. So, my Lord, in my skeleton, para 13, I set it out at the skeleton, so I don't think I need to go into the bundle, but this is how the point arose during the examination process. The inspector had asked, in some initial questions, evidence about Waverley's ability to meet Housing Market Authority unmet need, but the point crystallises in the agenda for the hearings themselves. I give the reference and quote that at para 13. I draw attention to how the inspector is putting it. Having regard to the MPPF, he says, Waverley should meet a proportion of Woking's unmet need. What figure should be set? So the focus is on proportion right away, rather than what the level of unmet need should be. And given my criticism of the inspector for not adequately engaging with the criticisms of the unmet need figure and the reading of that across, that's quite significant. My Lord, at para 15, I refer to the inspector's preliminary view on 50%. It does appear that he came to a preliminary view and then adhered to it. And para 16, I think a point that will be clear to the court that the reason for the concerns that the first appellant has is the impact of these houses on Waverley. So well, that brings me on to the grounds, and I think given the discussion we've had I can take those a little shortly. It starts on para 31 of the skeleton. I've already emphasised the two parts of this exercise and explained that, so I don't think I need to go back over that. The two components are need and supply, and it's critical that in this process the first opportunity that was given in terms of submissions on this point or the first stage of written submissions on this point is on the main modifications themselves, because what happened at the hearing is the inspector came to his preliminary review, asked the local planning authority to make main modifications. They did so by augmenting policy ALH8, and then there's a round of representations on that. The first appellant responded to the main modifications, and that's in the bundle at SB 209. That's the first appellant's response. There's some sort of introductory pages because of the nature of these forms. The text starts on 212.
Yeah.
And rather than read all of that out, simply draw the court's attention to reference to the MacDonald report, come to that, and then the summary point at A, about a third of the way down, the assessment of Waverley's unmet need, half of which the inspector wishes to impose on Waverley is unsound. Not the proportion, but the unmet need, being based on a mixture of out-of-date information and uncertain assumptions.
Is paragraph 2 the real guts of it, as it were?
Yes.
So if we read that, we've got what your client really wanted to say about this point.
Yes, it needs to be read with the McDonald report, if I can come to that.
Yes. The McDonald report stands behind it.
In this, it's paragraph 2. The McDonald report then starts on page 215. And it starts, I think, helpfully with an executive summary on 218. First substantive text inside the report. And at Roman 4, the Lordship will see a summary of the case. Again, attacking not the proportion, but the underlying unmet need. A series of assumptions, each of which is highly uncertain. Roman 4a on need, Roman 4b on supply, Roman 4c on timing. And note at Roman 6 that Neil MacDonald is referring to the PPG and suggesting to the inspector that, given the circumstances before him, one appropriate course of action, indeed the appropriate course of action, is to leave the matter for an early review.
One option. How does he put it?
He says the option. He says the appropriate course of action. So he's making that case very forceful. It's clearly raised before the inspector. Leave out the allocation, leave it for an early review. So that's the executive summary. The text itself on this point is at section 4, SB 223, and that section runs to SB 227, so it's section 4. For present purposes, and as I emphasised, I think in the skeleton argument in any event, what Neil MacDonald does is he takes the points about the actual OAN in turn. First of all, on 224, need. Criticising the reliance on the West Surrey SHMA. And this is the third bullet point down, noting its findings have not been subject to scrutiny in a local plan examination. There's been no plan scrutiny of that as it applies to Woking. And a point that's relevant to something that was appealed before the judge below on employment projections. In the second bullet point down, so the bullet point above, second sentence in, estimates of job growth are notoriously volatile. So it's criticising both bases of reliance on the SHMA.
That was a point quoted by the judge, wasn't it?
Yeah, I believe so. Certainly I took her to it. So
well, I remember the expression notoriously volatile.
my lord, then MacDonald moves on to supply. That's point B. And he criticises reliance on 292. Notes, third bullet point down, that that's from the South East Plan. Now revoked, of course. Then over the page on point C deals with timing, and point D deals with the 50% allocation. So it's addressing those things, but point A and B in my submission are critical, because what Neil MacDonald is doing is saying this unmet need figure, which is at the heart of this, is not sound. Your Lordships asked me earlier whether anyone invited the inspector to seek more information. The force, I think, of what Mr. MacDonald was saying on behalf of the first appellant was that these uncertain assumptions could not be relied upon untested. They needed to be tested on the points that were being raised. And indeed, his impression in the conclusion of paragraph 4.18, I think, gives a sense of how he saw things. 418 on 227. There, Mr. MacDonald says it would appear that the Waverley inspector did not appreciate the highly uncertain nature of the estimate of workers' housing needs he was offered. In particular, it's inconceivable he would have recommended a housing requirement based on untested evidence of Waverley's OAN, yet he is, MacDonald thinks doubtless unwittingly, proposing a substantial addition to the Waverley OAN, which depends crucially on an untested estimate of the Woking OAN. So, the representation before the inspector when he came to prepare his report was pretty clearly that there needed to be some engagement and testing of the objectively assessed need figure. And in my submission, the inspector simply did not do that, nor did he address the points in the MacDonald report. I accept, and we've been there earlier, but I accept that in the reasoning that one finds at paragraph 26 and following, so 26 through to 29, is the key reasoning, SB 11. The inspector flags some of these points, but he does so without addressing the points that were raised by Mr. MacDonald, apparently in the face of the out-of-date nature and unsoundness of the need and supply figures, and proceeds to address it entirely as a proportion rather than looking at the underlying figure. Well, there's a further point on supply I wanted to make. So I've mentioned the 292 South East Plan point. The question, a point was made before the inspector that actually I think this was a point was made particularly by Protect Our Waverley, the second appellant, that there are sites coming forward in Woking. Look at the actual supply in Woking. And clearly, standing back, actual supply is an essential ingredient for what is the unmet need.
So what is the point that this observation is directed to?
It's the AMRs, the annual monitoring reports.
Yes, but I'm sorry, we're not at a local plan examination at the moment. What is the point that these observations go to?
My lord, so it goes. This point goes further than MacDonald. The inspector would have had the opportunity to, and was required to, in my submission, also consider the robustness of his need of the unmet need calculation he came to against the supply. And again, it was a point that he flagged but did not factor into his assessment.
Is the point that there was evidence before the inspector as to brownfield sites coming forward in Woking that would have undermined the concept of supply which he appears to have accepted, and that he thus left out a material consideration? Is that the submission?
The submission is that the inspector didn't engage with this essential part of the test, so it goes a little further, but yes, it incorporates my lord's
I'm
submission.
trying to speak the language of public law, so if you could translate for me, that would help me. Where does this fit into the language of public law, Mr. Westerway?
My lord, it goes back to the exercise the inspector was required to do. Consider
Required by
assessed need.
Right, required by government policy. So is the submission that he failed to apply government policy because ... Is that the submission?
Yes. I mean, clearly there's a spectrum here, and there's an overlap. I mean, not applying government policy by having regard to a factor that one should have in applying government policy can be said to be a failure to have regard to material consideration.
So just to reunite ourselves with the policy, which policy did he fail to comply with by failing to do this?
It's as simple as the needs to calculate the objectively assessed need.
Right, so
on the basis of we're back in the MPPF.
Which passage of policy is it? You can just give us the reference if you wish.
Yes, well, I went to these.
You did.
And my lord, it's 158, 159.
Right. So, Inspector failed to take into account up-to-date evidence about supply in Woking. Is that the submission?
What he didn't do in coming to in the way the submission is wrapped up with, the inspector did not go to look at the objectively assessed need beyond this very simplistic exercise, where there were factors that ought to have led him to reconsider it, and instead, as I've said, he applied a proportion rather than considering the figure to which the proportion should be applied. That's the essential point, but it's underpinned, as my lord observes, by policy.
Well, I wasn't making any observation actually. I was simply identifying the basis for your point, and that seems to be it. And the evidence is just to identify where we find the evidence. You don't need to take, for my part, you don't need to take us to it, but just point us to where this evidence is.
Yes. So three just references. Your lordships would have noted the inspector did refer to at the some annual monitoring reports in para 29.
Just give us the
references. The most recent of those annual monitoring reports published actually in December 2017. So after there'd been submissions, but the most recent of those starts on page 284. Starts on page 284, and the supply position is set out on 293. The last reference, my lord, is my skeleton. Para 36 in my skeleton. Which considers what the implications of that supply position are for the 5 years. The maths is in footnote 8. If my learned friends object to the maths, then I'm sure they can say. But the maths is in footnote 8, and looking at those annual monitoring reports, one has a substantial supply that's shown.
So the unmet need comes down to 62
Yes,
by comparison with
225.
225.
And in my submission, it's not enough for the inspector simply to flag that there might possibly be higher delivery in Woking. He needed to engage with the implications of the supply position for his conclusion. And that's all the more so given the way that he put his conclusion, which is the unmet need has been growing and must be addressed now. Must be addressed now. The AMRs, which he appears to have looked at, he didn't ask for information on supply from any party. He didn't ask Woking for supply. Woking didn't provide any information on supply.
The AMRs told a different story as the submission.
But one looks at the AMRs and one can see a basis on which, in my submission, the inspector ought to have considered the objectively assessed need and to have reduced it downwards. Now, that really, so it's on from both sides. There was an unsoundness to the figures that were relied upon, but supply, there was simply a failure really to factor that in at all. My lords, in my skeleton on this point, it's para 37, I come to the conclusion, so I won't reiterate that. I think we've covered all of the ground. In my submission, even on the evidence available to the inspector, it was clear that significant downward adjustments needed making. And I say that by not doing that, the inspector acted inconsistently with guidance without giving reasons as to why, acted inconsistently with the approach he took to Waverley, and failed in terms of the fundamental exercise he was doing, even to identify the broad magnitude. And in my submission, there was some greater requirement of exactitude on him than just broad magnitude, but he didn't even do that. I was at para 39 and following the skeleton. I cover the point about seeking further information, and this is something that was plainly open to the inspector. I've taken your lordships to the policy on that I quote at para 45. And I refer at para 44 to the, and it's relevant here that this is an inquisitorial process, to the Tameside duty, and quote that. one additional reference on that point, my lords, which is the Dover case in the Supreme Court, which is at tab 16 of the authorities bundle. This was a development control decision about housing as it happens. Lots of issues were raised, but it was a reasons challenge that succeeded in the Court of Appeal and was upheld in the Supreme Court. The reference I want to take the court to is para 61 and following, page 23, para 61.
This is Lord Cullen.
This is Lord Palmer, with whom all of the others agreed. His was the only judgment. And here he comes to the decision in this case. The members of Dover, of the committee, had an unenviable task, he says. They'd only just received a report. New elements introduced of political significance. And then para 62, Lord Palmer quotes from the Model Council Planning Code and Protocol. And then Lord Palmer observed after that that what offers not only sound practical advice, but also reflects legal principle, and that legal principle is the Thameside principle.
Take reasonable steps to acquaint himself with the relevant information.
And that, in my submission, we have here a scenario that's analogous, at least in two respects, in that we have the planning practice guidance that I've quoted in the skeleton arguments, and I've taken your lordships to, saying that inspectors should be prepared to seek further information. And we have a position here where some very substantial concerns were raised, in my submission through no fault of the first appellant or the second appellant, just because of what happened at this process. There's no need to attribute blame to it, but very substantial concerns were raised late in that process and are left hanging and not addressed. My lords, I think I can take the rest of the skeleton largely as read. I'm conscious that I'm a little bit longer than I intended to be already, so I would hope to finish by now. At paragraph 46, my lords, I refer to what I've called the second option that was open in policy to the inspector, which, as invited by the housing market authorities, was to leave the matter for review. One doesn't know how the inspector thought about that. He doesn't mention it in his decision. He does mention a possible review of Woking, but that's a slightly different thing. And at paragraph 51 and following, I come back to really the key factual contention that the inspector needed to engage with the figure of unmet need before applying a proportion. Now I say, my lord, that there is a strong policy context that requires him to do that requires him to address the concerns that are raised about that figure. but in my submission it doesn't, it's simply not an answer to concerns about the underlying figure to say we'll take a proportion of them, 50%.
Well, just to cut through this, are you suggesting that to take, once you got to the point at which you had to decide on a proportion, if you properly got to that point, are you suggesting to us that to take 50% was perverse? I mean, the real point is, does it add anything, this argument?
It's in terms of what the inspector did, he focused almost exclusively on the proportion, so he didn't address the underlying point.
Yeah, but that doesn't go to my question.
It's slightly counterfactual. Had the inspector concluded that there was a low level of need, maybe 61, had he had regard to the AMRs in the short term, and perhaps built in the review and then said, well, half of that should be met in Waverley, I don't suppose I would be here. It's the high underlying number that's the issue.
Yeah. I mean,
and that's,
we simply need to understand how you put this. Do you actually say that in itself the 50% represents an irrational planning judgment?
no. It's as applied to the figure. It's the irrationality, my lord, is that the inspector used the 50% figure as in the proportion instead of addressing the underlying need. My lord, that then brings me on to the reasons challenge, and this links back to the objections that were made. This is paragraph 53 of the skeleton and following. Here, there is a criticism, and we make a criticism of 50%. I don't say necessarily irrational to apply that figure, but I do say that we do not understand the reasons as to why that figure is appropriate, having regard to the various factors and objections raised. So I don't make a rationality challenge against 50%, but I do make a reasons challenge, and in my submission that challenge has force because of the points that were raised in the MacDonald report. That's 53 of the skeleton. In terms of the law on reasons, I don't think there's any dispute. The reasons need to be given both by the inspector and by the defendant. I'll just draw the court's attention to the European element here, which is the 2004 regulations. Your lordships have those at tab just 2. The authorities bundle. This duty applies to the defendant, not to the inspector, because it's the defendant who adopted the inspector's reasoning and adopted this plan. It's Reg 16. So this is what must be included, how the particulars in subsection 1b3 and 3c3, which are documents that must be published when a plan is adopted, how environmental considerations have been integrated, that's A, 4a, how the environmental report's been taken into account, and then C, how opinions expressed in response to consultation, essentially, have been taken into account. So there's a duty, clearly, the give some specific substance to the porter duty that material principal considerations need to be addressed so that objectors, among others, know how their concerns have been dealt with. And in my submission, the problem of the 50% is it does not answer any of those concerns. And doesn't know how these various factors, some quite substantial, have any bearing in that 50%. My lord, the last point is in my skeleton at para 56, and it's simply the judge's indication after she'd considered the Dunsfold arguments. And this is in the judgment, para 64, that she would policy ALH1, so that's the principal one about which we complain. ALH1 should not be quashed in any event. It says the contribution of unmet needs is only a relatively small part, and it's inevitable. She says that a proportion, and probably a significant proportion, of Woking's undisputed level of unmet need would have to be met. So she exercised her discretion in that way. I'd note that none of the defendants in the High Court or respondents here invited the High Court judge to do that. In terms of would it make a difference, in my submission it plainly could make a difference, and indeed on the evidence before the court and the position now of Woking, there's every indication that it would make a difference if this unmet need figure were to be properly looked at in light of the points that were raised before the inspector, or further information was to be provided. That need figure would probably go down. Of course, might go up, but in a way that's the other side of the coin. It needed to be properly looked at. What the figure that was relied upon was simply not robust or up to date. And that was
so you say we'd have to quash the decision. And send it back to the Secretary of State to redetermine it.
I mean, in fairness, the judge addresses quashing and only quashing here. We didn't get to a stage because she was against us on the challenge where she was invited to consider directions.
Okay.
But this is where Woodfield and Gallagher, I think, provide a way through. And if the court was with us, entirely accept this challenge relates to a small part, but an important part, of a larger number of houses. Total numbers 500 or 600 or so. This is 83 per year. But still important. But there'd be no need for the entire 600 or so allocation to be knocked out. Just directions of the court that I'm sure could be under the approach in Woodfield and the powers that are provided in subsection 7 of section 113. That directions could be provided that just send the HMA authority need back and keep the rest.
I'm so sorry, forgive me, interrupt you. Have you formulated the relief?
No, my lord. I think we've reserved our position on directions, but in my submission, it would be readily capable of being formulated. I'd have to think about exactly how to do that, but
I mean, we're suggesting that you might put something together between 1 and 2 o'clock.
it's a very fair suggestion.
You should use your best endeavours to do so.
it's
You said it was very,
I shall,
you said
and
it was
I
very
shall-
simple, Mr. Wester.
and I shall talk to the other appellants as well. As far as I know that there have been communications between us and the defendant about this too, so I'll talk to my learned friends on both sides about that.
It would just save any potential to and fro later on, potentially. That is.
No, I can see the advantage of that. Unless your lordships had any questions, those are my submissions.
No, thank you very much.
Thank you, my Lords. I start, of course, by adopting and endorsing the submissions of my learned friend, the CPRE. My Lord Justice Patten indicated at the very outset his desire for me not to repeat submissions that have already been made. And of course, over the weekend, in anticipation of that, I'd already started preparing notes for submissions that wouldn't do that repetitive job. And indeed, there are only 8 points which I wish to make and to elaborate upon, albeit briefly. But it does strike me, in light of the time that I've been asked to start making my submissions, just 15 minutes before the luncheon adjournment, that it might be, and also my Lord Justice Lindblom's understandable desire to see a robust legal framework to the submissions, it does strike me that it might be helpful for me to actually hand up a one-page document with those 8 points on, to which I can then speak after lunch, having identified the legal authorities to which I will be referring
Wasn't you
my
asking
reference
us,
to them.
suggesting we adjourn now? And
No, I'm suggesting I hand in a document. It's all derived from my skeleton, but a document which is 1 page long, which encapsulates 8 simple points in I hope, a coherent order. I can then give you the legal references applicable to each of them as appropriate. You'll then know the route march I intend to go this afternoon, and I hope I could finish that in half an hour.
Route march or route map?
Route map. Route map. But if that's not of
yeah,
assistance,
no, of course,
I'm obliged. And if I can ask those to be handed up. Thank you, my lords. And also, it has the added advantage for your lordship, especially in light of what Lord Justice Patten said, that if there are points here that you feel have already been made to sufficient levels of exactitude, then I can skirt over them this afternoon.
Yeah, well, our concern obviously is that we finish the argument during the course of today, but
This will speed it.
but we don't want to prevent you making any submissions
No, of course.
you want to.
And I won't feel prevented.
Good.
The first point is simply this, and I'll develop to lesser or greater degree all of these points after the lunch and adjournment. The first point is simply this, that when it is decided to uplift one council's housing requirement to accommodate the unmet housing needs of another, it's necessarily an indispensable part of that exercise that the plan maker assess the OAN, the objectively assessed needs of both councils to some degree or the other. We cover that in paragraphs 4E and 4F of the skeleton, and I don't seek to elaborate upon it now, but I may do so if called upon this afternoon. But you have to look at the OAN of both authorities. Secondly, we know that when an inspector is assessing OAN for the purposes of determining a planning appeal, that inspector has to establish OAN to a reasonable level of accuracy and reliability. That's been held but by this court in Hallam, which is Authority 18, and in Gelson, Authority 19. And in so doing, that inspector, at a Section 78 appeal, has to properly apply the planning practice guidance in so doing. That's the second point. The third point is simply this, that the onus on an inspector conducting an examination into a local plan is even greater. That's for 2 reasons. First, because he's better placed to conduct that examination, and secondly, because that inspector is making an authoritative assessment which binds that authority in other cases. That's been decided in 3 cases, including in this court. It's been decided in Huntston, that's authority 9. It's been decided in Dartford at first instance, that's authority 14. And it's been decided in Shropshire at first instance again, that's authority 15.
Just, if you don't mind me just breaking in as you go, it's the word binds that's troubling me slightly.
Well, I take that simply from the judgment.
Yeah, but what does it mean?
It means we're in a plan-led system.
Yeah, but the binding is only a presumptive binding.
Yeah. It's a plan-led system. That clearly an allocation or a housing number in a local plan, in a plan-led system, has an authority outside of the single application of the Section 78.
Yes. I mean, once it's in the plan and the ink's dry on the plan, then the statutory priority, as I think Lord Clyde called it, applies to it in a development control decision. But other material
can indicate otherwise.
I mean, if for example, there's compelling evidence that, in the development control context, that brownfield sites are coming forward thick and fast in Woking, that might cast doubt on the headline figure in the Waverley plan in a development control context.
But the point is, if the word bind isn't appropriate, and it's the judge's word.
You didn't mean more than
that.
that.
I didn't mean more than that, no, of course. That's the fourth point. Third point. The fourth point is this. This follows from the PPG and also from my Lord Justice Lindblom's judgment in Jelson. We know that an assessment of OAN is an inexact science, but there are some parts of it which are exact. And they include the use of up-to-date government projections, demographic projections, as the starting point for identifying housing needs. And they also can include the up-to-date evidence of annual monitoring reports. And with great respect, if it is an inexact science, where we have points of exactitude, those points assume greater importance for that reason. And as a matter of law, since the starting point comes from policy, paragraphs 15 and 17 of the PPG, the proper interpretation of policy is a point of law, Tesco and Dundee. That's the fourth point. The fifth point is this, that while the inspector did use the correct up-to-date projections when assessing Waverley's OAN, he knowingly used out-of-date projections when assessing Woking's OAN. That's an inconsistent assessment. It resulted in an inflated outcome which was wrong. Inconsistency is a species of irrationality. That's North Wiltshire. It's King's Cross. There's a number of cases. Species of irrationality. And here we have an inconsistent approach to essentially the same issue, to 2 local authorities in the same housing market area and in the same report. That's the fifth point. The sixth point is this, that when the inspector deducted Woking's housing supply from his inflated assessment of objectively assessed needs to identify and quantify his identification of its unmet housing needs, he didn't actually investigate its actual supply at all, looking, for example, at AMRs, but he actually used housing requirement from a revoked plan as a proxy, a figure which tells you nothing about actual supply at all. Now, the use of such a figure was unlawful, held to be so in this court in Huntston when it was a proxy for need. Still more so must it be unlawful as a proxy for supply. It tells you only about planned supply. It doesn't tell you about actual supply at all. The seventh point is this. The inspector did that exercise in that way, even though he was bound in law to acquaint himself with the information necessary to make the best assessment of Woking's unmet needs on the material available. And even though that material was readily available to him.
Bound in law.
Bound or Tameside.
Right, so that you derive that proposition from Tameside.
I derive that proposition from Tameside, and indeed, my lord, I go one stage further. Your lordship identified local plan examinations as being essentially inquisitorial in nature.
Well, I think I said they were more inquisitorial than the distinctly adversarial.
They are certainly more inquisitorial than the distinctly adversarial planning appeal inquiry.
Section 78.
But they're more than that. They are essentially inquisitorial. Well, what the inspector does is conduct a structured discussion. In order to conduct that structured discussion, and having received the consultation responses from the various parties, the stakeholders, the inspector identifies and lists and tables questions to be answered.
So advocates are not generally, if at all, allowed to cross-examine
Not
other
entitled to
parties'
cross-examine.
witnesses.
This is a structured discussion where the inspector, even before the examination, asks questions. And so if you're looking at the Tameside duty, which is to make sure one has available to one as a decision maker the information necessary to do the job properly, in this part of the administrative decision making process, the examiner at a local planning examination is a paradigm example of the person placed so to do. And so if Tameside does have reach, as of course it does, it's seminal authority, it has real reach in local plan examinations. And to answer my Lord Justice Ryder's question, we're looking here for a pragmatic solution. Of course we're looking for a pragmatic solution. There are examinations up and down the country where an inspector is looking at allocations and numbers for one borough, but when there's information about housing needs across borough boundaries in a housing market area that knows no administrative boundaries because we're looking at a housing market. And of course the inspector has to adopt a fair and pragmatic approach. But at the very least we respectfully submit what that inspector must do is not take out of date OAN assessments as an input for one part of the exercise when he takes up-to-date assessments of OAN for the other, i.e. start from the correct starting point, the latest projections in all cases, that's the very least. And secondly, don't take a revoked figure for supply as a proxy, as a need, as a requirement, as a proxy for supply, when you can readily have available to you what the actual supply is. And that is something that any inspector, properly guided by this court, could simply ask of the relevant parties to equip him with, if faced, as many will be, if faced with the possibility that there may be unmet needs in one part of the HMA which are properly and possibly to be met in another part of the HMA. That's not an onerous burden. All that means is that the inspector is equipping himself properly to the task at hand. And that task is an important one. Because here, the uplift made was 21% on demographic needs for this one particular borough. 21% to meet the unmet needs elsewhere. That was on top of an uplift of 25% for affordability reasons. And what that means is that in an authority that only has needs, demographic needs for 7,500 homes over the next 19 years, is being asked to build 11,200. And he's been asked to build that where 92% is the countryside, with 3/4 of that countryside is AOMB, or areas of outstanding natural beauty, or areas of great landscape value, and 60% is greenbelt. And so these figures really matter. And the point of principle as to what the approach should be for an inspector when he's looking at how to assess the unmet needs of one authority and impose them on another really matters. And that is with respect why Lord Justice Singh gave permission for this appeal to proceed. That, by way of summary, is what I'll be addressing you on this afternoon. It may be in light of that accelerated summary, you can feel I can take some of the points rather quicker than others, but I'll take your lead on that.
You're taking point 8 as read, are you?
Oh, well, I'm taking point 8 as read because this deals with the point that you were making about the proportion. The 50% may well be a sensible proportion. There are only 3 authorities in this HMA. And if you're meeting the unmet needs of one of them, one can readily see why you might therefore divide it up between the remaining 2, at least at first blush. But half the wrong figure is still the wrong figure. And here, as I'll come on to this afternoon, we're talking thousands.
So like Mr. Westerway before you, as I sense from what you've just said to us, you're not submitting that per se the 50% is an irrational approach.
I'm not specifically doing that. What I'm saying, it doesn't have any nexus to any of the uncertainties that have previously been identified. It's simply dividing up the figure he'd wrongly come to, but by the 2 remaining authorities in the HMA. That's what it looks like to us. Obliged.
All right. Well, we'll adjourn until 2 o'clock. Thank you.
What, right?